with that, I will call the first case, which is case number 165961, the Attorney General versus Eli Lilly and Company. This is a grant, 20 minutes of argument per side. Let me look here. So I believe an attorney for Michigan Association of Justice will have an additional 5 minutes. And Mr. Fowler, if obviously you have 2 minutes of fire-free zone, if you'd like to save some time for rebuttal, you may. We just ask that you keep track of that. And you may begin when you are ready.
Thank you and good morning. Assistant Attorney General Darren Fowler, may it please the court, presenting on behalf of Attorney General Dana Nessel. With me at council table this morning is Deputy Solicitor General Eric Restucia, and next to him is the attorney Paul Novak from the Michigan Association of Justice. I would like to reserve 2 minutes for rebuttal. The Michigan Consumer Protection Act was broadly written to protect consumers from price gouging and deception in a broad range of purchases for personal, family, and household purposes. This court's decisions in Smith and Liss rewrote the Act's primary exemption to sweep out of its protective coverage purchases for groceries, automobiles, home improvements, prescription medications, and a broad range of other things that fall under the Smith-Liss concept of general transactions. What the legislature intended as a seldom used side road was transformed into an expressway for those engaged in exploitation. This morning, I am eager to discuss with you the defects in Smith and Liss and why they should be reversed. But first, I will discuss how the Attorney General met the prerequisites for seeking a declaratory judgment, and I will respond to Lilly's illogical proposition that in order to investigate whether there has been a violation of the Michigan Consumer Protection Act, the Attorney General must somehow plead a claim that the Act has been violated. A declaratory judgment complaint requires the showing of an actual controversy. Lilly's argument that the Attorney General was required to also make some companion claim of a violation under the Michigan Consumer Protection Act is wrong, and it is contradicted by the precedents of this court in decisions like Michigan Home Builders and Dime Brands. In Michigan Home Builders, this court allowed a declaratory judgment, but only after first holding that the plaintiffs there had no implicit or explicit cause of action in tort for money damages. And in Dime Brands, this court reviewed a matter involving the plaintiff's request for a declaratory judgment related to a statute of limitations, a defense that is analogous to the exemption at issue here. And the Dime Brands plaintiffs certainly were not required to prove that the treasurer had a valid cause of action against them as a prerequisite to getting a declaratory judgment related to a defense. That kind of keys into the other aspect of the declaratory judgment rule, which speaks to it doesn't matter whether or not other relief is or could be sought. Here, the Attorney General was not required to bring an investigative petition to launch an insulin investigation into Eli Lilly. What the Attorney General was required to do under the declaratory judgment rule was to give evidence of a sincere intention to invoke the Consumer Protection Act against Lilly in a way that would be adversarial and would implicate the Section 4 exemption. The petition happened to be the crystallization of the Attorney General's sincere intention, but the fact that we have spent approximately 4 years now arguing about the Smith and Liss issue from the Circuit Court up to the Court of Appeals, up to this court through multiple briefs, demonstrates that there is this adversarial relationship between the Attorney General and Eli Lilly that forms the kind of actual controversy that this rule is designed to open the courthouse doors for, to help promote those kinds of efficiencies in the judicial process. Lilly, now that there is an investigative petition, is trying to use it and attacks upon it as a proxy for launching an attack on the concept of whether there's an actual controversy, which legitimately it cannot dispute. But Lilly's attacks on the petition are wrong on both a macro level and on micro levels. On a macro level, they are misconstruing Section 7. Lilly thinks that somehow Section 7 should be construed to require a claim to be pled that it can then attack on a C8-type motion. But what Section 7 of the Consumer Protection Act requires is for the Attorney General to show probable cause to believe that a method, act, or practice made unlawful of the act is occurring. And that is what the Attorney General did in the Circuit Court through a factual presentation of evidence showing how the kind of method, act, or practice made unlawful by two different subsections in sub 3 are being violated. That insulin, for example, Lilly is charging a price grossly in excess of the price at which other insulin products are being sold.
Mr. Fowler, are you familiar with the case of Shavers versus Attorney General? It has nothing to do with the Michigan Consumer Protection Act, actually. It's a no-fault decision written by Justice Levin. Are you familiar with that case?
I am, Justice.
It was a rather lengthy opinion that described every aspect of the No-Fault Act after the No-Fault Act was passed in the 1970s. If an insurance company believed that Shavers versus Attorney General was wrongly decided, and they issue policies of no-fault insurance, can they just file a deck action and come in and say, Shavers was wrong, fix it for us, court?
There has to be some type of adversarial relationship that properly presents the court, and I think there'd have to be...
Sure, there would be. Insurance companies issue no-fault insurance policies all the time. They've got thousands of adversarial relationships there. Can they do that then?
If a party has a good faith belief that a law is unconstitutional or a case has been wrongly decided, they can take action, but I don't believe they can act in contradiction to the law or the controlling precedents.
So your position is if you have a good faith belief that the court wrongly decided a case, you can bring a deck action to have the court look at the question?
Yes, Your Honor.
Presumably, that would be like if you were challenging a contract provision or something, and it was running into the No-Fault Act in our interpretation of something, then maybe I would assume that's how it would be styled.
What I would say is in Justice Zara's hypothetical, there was an effort to do something in contradiction to the law. Here, we articulated our concerns with the precedent overtly so that Eli Lilly could meet the challenge. Eli Lilly wasn't prejudiced by an effort to do something that contradicted a precedent of this court. We put the cards on the table, showed what we were doing, and gave Eli Lilly an opportunity to invoke the defense, which it did because it had an adversarial interest in doing.
Can I come to the petition? The circuit court found there was probable cause on the petition to issue the subpoenas. Could Eli Lilly have appealed that finding of probable cause?
The mechanism under the Consumer Protection Act for them to start with would be to bring a motion to quash, and Eli Lilly opted not to do that. They brought a motion to stay in that circuit court file that has the petition, which is a different file than we're here about today, saying we think that reviewing the Smith or invoking the Smith and List concept is the most efficient approach on which to go forward. So rather than bring a motion to quash, laying out the other concerns we have with the petition, this is the ground we're going to fight on. And so,
and then the decision on that motion to quash could have been appealed one way or the other, correct? And had the circuit court found that there wasn't probable cause, perhaps because of Smith and List, could the Attorney General then have appealed that finding?
yes.
So the petition finding probable cause is the case, is that because it's the controversy, right? I tend to analogize these to, in the insurance context, right, to a deck action where you have an underlying tort suit that implicates perhaps the duty to defend or duty to provide coverage. And the insurer, while they could join the tort suit and litigate that coverage issue in the tort suit, also has the ability, because of the existence of a controversy, can then file a DEC action and proceed to find the coverage or litigate the coverage issue, including challenging perhaps existing precedent. Okay.
Correct. Here, the petition crystallized the controversy. There could have been other ways that this controversy could have been presented through different evidence. But I think that the way we have presented it demonstrates the true adversarial nature of what is happening. We are seeking to investigate Lilly, and that's very overtly stated and explained. The other aspect of what Lilly does in relation to the petition is try to say that Section 7 says you've got to frame out allegations. But what Lilly is really doing there is ignoring the placement of the word allegations within Section 7 and really reading it in a way that's not consistent with a reasonable investigative purpose. What the Section 7 says is that after the showing of probable cause, the Attorney General can ask questions of the party and make the party produce documents relating to allegations that the act has been violated. So in other words, upon showing the factual evidence of a potential violation, the Attorney General can then gather evidence to determine whether or not there is in fact a claim that can be made and then framed out in a lawsuit. On a micro level, Lilly's arguments are simply not well stated. They're not supported by law. I'll give just one quick example. Lilly makes kind of a bald assertion that branded and unbranded medications are dissimilar as a matter of law under the CPA. Lilly points to no case law under the Consumer Protection Act justifying that position. They vaguely point to some case law that says brand names have value. But Lilly's argument, besides having no support in any law, defies reason and would make that subsection Z about grossly excessive pricing a dead letter if it were adopted. Every good or service is sold under somebody's brand name. And if simply pointing to yours and saying, well, that has value beyond anybody else's is a legal defense, as Lilly suggests, then no claim is ever going to be able to survive that kind of test.
Counsel, is there any other way, short of doing an investigative subpoena for the Attorney General's office to sort of move forward to a complaint stage, or is this sort of the normal protocol? You have to get the investigative subpoena first to see if there's more there.
There are different pathways. The Attorney General could move directly to a lawsuit instead of an investigation. I think that the complexity of insulin sales and what goes on with Lilly justify doing a deeper dive in this context. But certainly other pathways, like simply issuing a notice of intended action under Section 5, which kind of begins a negotiating period for 10 days. And if that doesn't succeed, then we can bring a lawsuit. So that is the other pathway the Act anticipates. The Smith and List decisions are premised really on two major flaws. The first is writing that word general into the plain text about specifically authorized transactions or conduct. The other is tying the concept of a general transaction to some sort of regulatory scheme. Now, in its briefing, Lilly has tried to make this argument that the Attorney General is somehow reading transaction out of the Act. And I want to take a moment to give an example. It's one alluded to in our briefing, and I started to discuss when I was here 13 months ago, and that is a MSHDA-approved lease transaction, which is a specifically authorized kind of transaction. Imagine that John Jones enters into a lease with Atlas Properties that is a MSHDA landlord. Atlas Properties advertises on its website that all of its MSHDA properties have 1,200 square feet and come with brand new furniture. If Jones has his lease with Mishta approved, and it has contents that include square footage and price and says nothing about the kind of furniture in there. It's still a specifically authorized transaction. So Jones is not going to be able to invoke the Consumer Protection Act to try to set that transaction aside. That's true even if Jones wanted to say, hey, that approval from Mishta didn't say anything about the furniture, because that is a specifically authorized transaction between Jones and Atlas by a government agency, Mishta. But that doesn't mean there's no remedy for Michigan consumers here to help protect themselves under the Attorney General's construction. The Attorney General can still bring an action about the misleading conduct, those deceptive representations on Atlas's website under Section 5, seeking an injunction against those continued misrepresentations. What the Attorney General cannot do is bring an action for Jones and other Mishta people who have these specifically authorized lease transactions and try to invoke Section 10 sub 2 that generally allows the provision of termination or modification of contracts. Here, those transactions are specifically authorized, and the Act says we can't apply the exemption against them, but we can still reach the conduct.
Counselor, how would you define transaction? It's not that the specific transaction with Mr. Jones is authorized, right? It's a general category of transactions with Jones or Smith or whoever that has a particular nature. That's the authorization. Is that the scope of your argument, or is it something different than that?
No, that the transaction is the specific transaction between Jones and Atlas. Reading Section 3 of the Act and the various unfair trade practices, that term, a transaction, is used multiple times. And I call your attention to provisions like subsections M and T that talk about how a sales agent can't make a misrepresentation in a transaction, or how a person has to be given appropriate notice of a waiver of a right in a transaction. Section 3 speaks to transactions in this kind of singular way, or the way that they would be brought by a private plaintiff seeking to invoke the Consumer Protection Act to their benefit under Section 11. Smith and Liss, and now Lilly, embrace this kind of broad, generalized categorization of transaction as somehow embracing more. The problem, and the flip, is that Lilly has committed the kind of mistake that it is trying to put onto the Attorney General. Lilly's broad conceptualization of transaction actually reads conduct out of the Act. And that kind of note to do that really started with the Smith court. After that big block quote from Diamond Mortgage, Smith completely misstates what Diamond Mortgage held and says, in other words, Diamond Mortgage instructs that the focus is on whether the transaction and not the alleged misconduct is specifically authorized. We know that can't be right because the statute speaks to transaction or conduct on equal footing. Lilly gives no examples of any instances where the courts have ever tried to sort out the difference between an authorized transaction or a specifically authorized transaction. Lilly doesn't frame out any kind of case where a court moved on from transaction not being applicable under 4 and then did an analysis whether or not the conduct was specifically authorized. All they were able
Mr.
to...
Fowler, you have just under 2 minutes. I just wanted to remind you of that in case you wanted to save time.
Thank you. I would like to hold that time for my rebuttal, and I appreciate the cue.
Thank you.
Thank you, Your Honors. Paul Novak on behalf of the Michigan Association for Justice. I think for purposes of framing my discussion before you today, it's helpful to look at 2 documents. First is Exhibit 3 that we appended to our brief, which is an actual FDA approval letter for Humalog, one of the insulin products that are at issue in this litigation. That FDA approval letter provides, as the FDA is authorized to do, that Humalog is safe and effective for use as recommended in the draft carton. The FDA approval letter indicates that there is specific authorization for certain conduct, how Humalog may be labeled, the uses for which Humalog may be marketed, can be used to treat diabetes, but nothing about cancer or dementia. And it requires Lilly to update the FDA if new information related to the safety and effectiveness of the drug become available. Contrast that exhibit and what is authorized there with another exhibit that we also appended to our brief, and that is the complaint that the California Attorney General's office has filed under their Consumer Protection Act 17200. And by the way, there are roughly 15 state attorneys general who are now in active litigation over the issue of insulin pricing that the Attorney General is attempting to investigate. Now, the California AG's complaint identifies certain conduct. It alleges that there's been over a 600% increase in insulin prices instituted by the manufacturers of insulin, including Eli Lilly, coinciding with massive rebate payments to pharmaceutical benefits managers, some characterize them as kickbacks, that actually led to the increase in the retail price. And it also alleges that manufacturers made misleading statements about why the prices were so high. If you take the FDA authorization letter and say that that specifically authorized certain conduct, none of that conduct is what the California Attorney General alleges was unlawful. So the specifically authorized conduct exemption does Lilly no good. What it needs to do, and what Smith and Liss erroneously, in my view, enable it to do, is engage in a two-step. Step one, recharacterize the specific authorization of conduct that is referenced in the FDA letter, Exhibit 3, and instead, under the Smith and Liss erroneous rubric, recharacterize it as specific authorization of a general transaction. That's step one. Step two, now that we've got a general transaction authorization, extend immunity to essentially transaction-wide. And the consequence of that is that all types of conduct that goes well beyond what the FDA authorized in its 1996 approval letter is now characterized as exempt. Under the two-step approach that Lilly takes, you can pay kickbacks to other industry participants, causing massive increases in the price of the product to a consumer, but that's under a general transaction immunity, something that is now exempt. Under the two-step that Lilly proposes to this court, you could fix prices with competitors, and since the general transaction has blanket immunity, that conduct would be exempt. Under the two-step, even off-label marketing of the drug, something that we also appended to our brief as Appendix 4, the instance where Eli Lilly pled guilty to the criminal off-label marketing of the drug Zyprexa, paid a $500 million criminal fine. That was not conduct that was specifically authorized by the FDA. In fact, the United States brought a criminal case against Lilly for that conduct. It clearly wasn't specifically authorized. But if you use the two-step that is enabled by Smith and Liss, you can take clearly criminal conduct and say, now it has been specifically authorized as part of a general transaction. And since we have general transaction immunity that is transaction-wide, we are now exempt from the Consumer Protection Act.
Thank you, Mr. Novak. Your time is up. Thank you.
Thank you, Chief Justice Kavanaugh. May it please the court, John O'Quinn on behalf of Eli Lilly. 40 years ago, in a case called Keckle versus Allstate, the Court of Appeals unanimously applied this court's decision in Diamond Mortgage to Section 4.1a's disjunctive transaction or conduct exception and adopted the interpretation that the Attorney General now seeks to challenge. This court, in turn, endorsed that interpretation over 26 years ago in Smith versus Globe Life, rejecting the argument that the exception was limited to specifically approved transactions or to specific aspects of a transaction. It was enough that there is a transaction that is specifically authorized. And in the intervening decades, the legislature has since revised and amended the Consumer Protection Act some 23 different times, including revising Section 4's exemptions on 3 separate occasions while readopting the language that Keckle and Smith interpreted, but making other changes to other provisions based on disagreement with other interpretations of this court. This unbroken chain is powerful evidence that this court's prior decisions were correct, but at a minimum that the application of stare decisis is at its zenith. But this court need not and should not reach those issues, because this is an improper test case under the declaratory judgment provisions. The Attorney General puts the cart before the horse in asking this court to decide the contours of an exemption, in the department's words, a quote, affirmative defense, as a threshold matter where the department has declined to show any legally viable violation has been alleged in the first place, which 445-907-1 requires. It refers to related to an alleged violation of the act. And so there's whether the exemption is even relevant here ultimately depends on future contingencies, and is certainly not necessary to the resolution of this dispute under a long line of cases such as Lansing Schools, Associated Builders, Shavers, and all the way back to Anway versus Grand Rapid Railroads over 100 years ago. This court has rejected such a use of a declaratory judgment action. This court should do the same here and either dismiss this appeal or affirm.
Okay, since you said, I want to get to the declaratory judgment question, and you cited Lansing Schools. In that action, it was a declaratory action in which this court overruled 6 of its prior decisions regarding the proper measure of standing. And in that case, the individual plaintiffs who had alleged they had been assaulted and you know, that the school's policy violated the mandatory duty to expel students was violated, and in a separate declaratory judgment action, the school challenged the standing. I'm sorry, not the school. The school district challenged against the Board of Education standing. So there was a controversy in the underlying suits, and again, like sort of using my analogy, and maybe you can tell me if where my analogy is inapt. But in a insurance coverage issue, there is a controversy because there's been an assertion of tort liability against an insured, and there may be any number of defenses, right? It didn't happen. There was a self-defense, whatever it may be. But for purposes of determining the legal question of whether it was an occurrence or an intentional act or some exception applied, the insurer, although they could join the suit, can initiate a separate DEC action to challenge the legal premise that will guide that question or the legal analysis. Why is the fact that the petition was filed, a judge found probable cause, that hasn't been challenged? Why is that petition not a controversy that justifies this DEC action? In particular, where both parties agreed that this legal question is what controls the viability of that petition.
So, Chief Justice Kavanaugh, there's a lot packed into that question. Let me try to break some of that down. First of all, I think there are a couple of different issues in the context of the propriety of deciding an issue like this in the context of a declaratory judgment action. One is whether or not there's an actual controversy within the meaning of Article 6 in the first place. Next is prudential doctrines about whether or not it is a proper discretionary use of declaratory judgment action when it is not necessary to the resolution, or it depends on future contingencies that may happen or may not happen in the future. Now, in your hypothetical, I think that there's no dispute that there's an actual underlying claim. Here, there is a vigorous dispute, at least on our side of the V, of whether or not there's an actual underlying claim. But tellingly, the Attorney General has declined to defend that, despite 2 direct orders from this court asking the Attorney General whether or not the department had stated a claim. And I think that under these circumstances, that, number one, presents a hard question of whether or not there's an actual controversy here when the Attorney General is not willing, despite 2 orders from this court, to actually defend that there is a claim on an actual legally viable theory, even assuming all of the facts, not challenging the facts, not challenging whether they have pled sufficient facts for purposes of pursuing an investigation, but pled facts that, if accepted, would give rise to a viable legal violation. We have laid out...
What do you do with the circuit court's finding that there was probable cause?
So Chief Justice Kavanaugh, there's 2 problems with that. First of all, this was issued routinely the next day as a matter of course, when on the Attorney General's own admission it shouldn't have been issued, because the Attorney General's own petition acknowledged that under Smith and List that the Attorney General couldn't proceed. So the idea that essentially there was a rubber stamp finding of probable cause when the Attorney General in that very petition conceded that the action couldn't go forward means I don't think you can put any weight to that.
Well, but you could have challenged that then in a motion to quash. But in lieu of proceeding in that, you stipulated to pause that and pursue this legal determination of the controlling law in the DEC action. It seems a little bit to me like you're wanting to have your cake and eat it too.
So respectfully, Chief Justice Kavanaugh, I think it's the Attorney General who is doing that. And the reason that I say that is because, let's be clear what the Attorney General did. The Attorney General filed its investigative action. It simultaneously filed the declaratory judgment action. The parties then, and in both of which it admitted that for purposes of proceedings in the lower courts, the outcome was entirely controlled by this court's decisions in Smith and List. And so, we did not yet file a motion to quash. If we had, yes, there are a number of issues that it would have raised, including the arguments that we've made in our briefing in this court in response to this court's order.
So if it had been a motion to quash, could we get, at that point, would we be permitted to get to the merits of Smith and List?
It potentially, Justice Welch, it would depend on, candidly, it would depend on how the issues were resolved. That goes to the impropriety of deciding this issue in this affirmative defense in this context, because you would have had gating issues, like whether or not there was a legally viable theory in the first place. And to be clear, Chief Justice Kavanaugh, we responded, yes, in the lower courts, accepted the Attorney General's concession that the case couldn't proceed. But both in the bypass application, when they sought to bypass the Court of Appeals, in our opposition for leave to appeal, in our supplemental brief, we laid out and explained why this was an improper test case, and at a bare minimum, this court should not exercise its discretionary jurisdiction to reach it in this artificial trumped-up context.
Counselor, you're saying this is a matter of our prudential doctrine, right? You're saying that there are a number of other defenses or assertions that you might have made and still might be able to make, but I'm looking at your C8 motion in this action, and the only claim raised in that C8 motion is the one that we're here on right now. And so that's the one that you have drawn the court's attention to in the lower court, and which the lower court decided on. So you didn't raise at that point these other potentially very viable alternative grounds. That's the one that you had us focus on. So your argument is that prudentially we shouldn't do it, but not that it's not before us.
So Justice Thomas, I think two aspects to it. You are correct that in the trial court, we accepted the Attorney General's concession. We didn't litigate other issues in front of the trial court that were, given the Attorney General had conceded that the matter could not proceed under existing precedent. That, as opposed to wasting that court's time and resources and so forth on when you had this concession. Now, in terms of where we find ourselves now, At a bare minimum, I agree. Under the Declaratory Judgment Act, because this is neither necessary, I mean, if you look at the Attorney General's petition, and this is at Appendix 6, says that the theory for why there's a controversy is that Eli Lilly, quote, may attempt to assert Smith and List preclude any subsequent MCPA lawsuit. And similarly, and this is at Appendix 42 to 43, Eli Lilly may attempt to rely on Smith and List, and it would be a waste of resources to proceed with the investigation if Eli Lilly raised the opinions in a lawsuit. All of which shows that this is contingent. Exactly what this court's precedents on declaratory judgment say is improper use of a declaratory judgment action. Now, I do think that there is a hard question here as to whether there is an actual controversy to begin with. Antecedent, yes, the exception could always be potentially asserted in the way that the Attorney General has manufactured this case. But that's the point, is it's a manufactured case. Because number one, there is no allegation.
But Counselor, weren't you free in the C8 to say there's no case or controversy and we don't even need to get to this legal question?
Well, respectfully, Justice Thomas, I think we find ourselves in a little bit of a different situation because it wasn't until this court asked the question. We did engage. We did point out in the Court of Appeals that the underlying legal theory here was not a viable one. The Attorney General offered no response on that whatsoever. This court then asked the question to the Attorney General, not once, but twice. And the Attorney General's response the first time was, quote, the Attorney General disagrees with the legal premise appearing to underline this court's order for supplemental briefing, end quote. And then it's in this court's second order asking the same question again, the Attorney General, again, doesn't engage in the merits. The first engagement on the merits that we've heard is a little bit today, but even that doesn't address the question that their own petition is self-defeating under whether or not there's improper pricing. It has to, under the provision they've invoked, it has to be pricing to consumers. And they admit at Appendix 12, 14, and 42, all as part of their underlying action, that Lilly's sales are to commercial buyers, not to consumers. So right there, the provision that they're invoking is inapplicable before you even get to questions of whether or not the Attorney General's theory would violate the Commerce Clause, would be preempted under federal law, or all of these other issues. And the fact that, again, despite 2 orders from this court, the Attorney General has failed to engage, number one, I think should give the court pause of whether there's actually an antecedent controversy before jumping into answering the question about the scope of an exemption. And number two, prudentially, whether you should do it. And again, part of the problem with doing that is you might want a case in which if you're going to ask questions about precedent and how it should be applied, where the contours of it have actually been litigated. Going to questions sort of like the one that you asked a few minutes ago, Justice Thomas, about doesn't the statute refer to a category of transactions? Isn't that what's being referred to? And shifting to the merits, that's absolutely right. It does, and that has to be true. And so that both the Attorney General's theory and Amicus's theory, and by the way, they don't even disagree. The Attorney General, and I'll come back to this in a minute, the Attorney General says if you have a particular transaction that's been authorized, that exempts the whole transaction. I don't know why that wouldn't apply to this very, very specific authorizations at issue here. When the FDA authorizes the insulin sales, it gets down to the packaging, the labeling, the use, essentially everything about it except the price. But the Attorney General, in the hypothetical a moment ago, agreed that if you had a specifically approved transaction, that there could be aspects of the transaction that the agency had opined on. So I don't really understand the difference. If you had a crystal case, you could be deciding sort of the breadth of this. But back to your question, the statute and the exemption 4(1)(a) says this act does not apply to the following: a transaction or conduct specifically authorized under laws administered by a regulatory board or officer. It doesn't say authorized by an agency. It says authorized under laws. And of course, laws, which are prospective in nature, have to authorize things in a categorical way. They're generally not going to have a very, very specific particular transaction in front of them. And the statute doesn't refer to a specific transaction or specific aspects of a transaction. It could be written that way. That is how Virginia's is written. That is how Maine's is written. Other states don't have, many other states don't have the word transaction in them at all.
So, Counselor, let me understand the scope of your argument on transactions. So if laws regulate packaging, that seems clear that that's within the category of transactions that can't be reached, that's exempt. But I also understood some of your pleadings to suggest that just the fact that something's in a regulated industry, then that means it's completely exempt. And so it seems to me there's quite a bit of space between those two understandings. Where is your position?
Yeah, my position is the position that this court articulated in lists. It's not the actor that is exempt. The fact that you're in a regulated industry doesn't serve to exempt a party. The fact that you are a regulated party doesn't serve to exempt the party. What exempts the party is the party engaged in an authorized transaction? And if so, then the legislature has made the policy determination to provide breathing space that we're not going to allow the MCPA to be used to further regulate how you conduct that transaction.
So how do you address the point made by Mr. Novak, that even then criminal conduct that has been found to violate a statute and be criminally liable would nonetheless be exempted from action under the Consumer Protection Act because generally the conduct is authorized?
Yeah, so Chief Justice Kavanaugh, a couple of responses. First of all, as a starting point, the MCPA exemption only applies, only gives an exemption to the MCPA. It is not an exemption from all law. It's not an exemption from other law. If somebody has been found liable or is liable or criminally liable under other laws, then the MCPA doesn't speak to that. If you have, though, a specifically authorized transaction, and somebody wants to attach the label to it that it's wrongful, it's criminal, it's unlawful, this court addressed that in Diamond Mortgage itself. In Diamond, it says, quote, "The exemption will nevertheless apply where a party seeks to attach such labels to a transaction or conduct specifically authorized under laws administered by a regulatory board." That's page 617 of the Diamond Mortgage decision. And so the fact that there are other laws that may address other issues means that it is, it is no import that it may turn out to be exempt under the MCPA if the exemption is applicable. It doesn't make it exempt from everything else.
Counsel, so I have the act in front of me, or at least some of the act, and there's literally 5 pages of prohibited conduct or transactions or conduct under the Michigan Consumer Protection Act. And then we have the exemption. Why is the interpretation of Smith and Liss and what you are advocating for not? It seems like it just swallows the whole act. Why would the legislature take all the time to outline all this behavior that is not okay and then exempt it all?
So Justice Welch, respectfully, I disagree with the premise that it's all been exempted. And if you look at, for example, and I think that's wrong in terms of how the courts of appeals, the Court of Appeal has been applying it, the law in Michigan, and it's wrong on the facts in practice. If you look at cases that we cite in our brief, like the Pettinelli case, the Brown Law case, the Hinderer case, they all give great examples of where the act is applicable and has teeth, even though, yes, there are things that in a regulated industry, if the regulated entity is engaged in the things that they've been specifically authorized to do, those things are exempt. And the fact that the MCPA is so broad and frankly so vague, that we have here an attempt to regulate nationwide pharmaceutical pricing with a price gouging provision shows exactly why it was a wise policy judgment for the legislature to draw the line that it did. But whatever you think of Smith when it was originally decided, this court, of course, has to grapple with the fact that this exact same language has been reenacted multiple times now in 2000 and 2003, in 2014, and that it shows that there's been an ongoing conversation between the legislature and the courts over what the scope of the MCPA's exemptions should in fact be. And it would, there are multiple, during the course of this litigation, there have been some half a dozen bills that have been introduced that would wipe away the transaction exemption, that would make the exemption look like that of many, many other states, as opposed to the way that this one is written. And the legislature hasn't yet acted on that. But the fact that the legislature has repeatedly acted in response to court decisions, building on the edifice of Smith and List, disagreeing with other aspects of Smith, but not the issue that we are here discussing today, shows, number one, that under the reenactment doctrine, the decision should not be overturned, and number two, that stare decisis, statutory stare decisis, is at its zenith, and this court should uphold its existing precedent. I'm happy to answer additional questions should the court have them.
Thank you, Mr. Quinn.
Thank you, Chief Justice Kavanaugh.
Mr. Fowler?
Thank you. Had Lilly brought this motion to quash that it agreed not to bring in the circuit court, the circuit judge was always going to confront Smith and List. And that was most likely, for a very busy circuit court, always going to be the dispositive question, rather than then also going on to reach all these hypothetical constitutional and other legal challenges that Lilly is now trying to mount for the first time on appeal. Counsel invited the court to look at Keckle as kind of the origin of the Smith-List analysis. It really is. Please do look at it. All it says is that something has to be subject to regulatory control to invoke the exemption. There's no invocation of the specifically authorized aspect of the text. There's no real meaning in that decision. It is the origin story of a supervillain that became radioactive when the Smith court then also engrafted the word general into that exemption and said now when you're talking about a general transaction subject to regulatory control, it sweeps in everything that goes on, whether those acts speak to it or not. Sear versus Ford Motor Company is a Court of Appeals decision where the court just lays out all the laws that apply in an industry, does nothing to try to pinpoint the conduct or what's involved in that case with any of those regulations.
Counsel, how do you respond to brother counsel's claim that Michigan's language in the Consumer Protection Act is different than other states, and therefore they're more free to interpret them in a more favorable way for consumers?
I'd simply invite the court to look at cases, like I said last time, Chapman from GM's brief. Most recently, GM dropped Chapman and went with Tijerino. We see in real time Consumer Protection Act claims being made by Michigan and various other states throughout the country. In Chapman, 37 attorneys general's cases were allowed to go forward under their consumer laws. Only Michigan was dismissed because of this kind of safe harbor exemption. Tijerino, again, Michigan, the only one. I know my time is up. Smith and List are contradictory to the plain language of the statute. They bewilder consumers who would read the act. Please make it a brief detour in Michigan consumer protection case law. Thank you for your time.
Thank you. The case will be submitted.